Thank you, Your Honor.
And we'll give you guys just a minute and then we'll play some musical chairs and let everyone come forward. All right, the second case on this afternoon's docket is case number 127303 from Leavenworth County, State of Kansas, Appalachia versus Eric Jerome Brown, appellant. Please come forward, and when you're ready, parties, please state your appearances. Just state your appearances first and then come on forward. Yes.
Andy McGowan with the Appellate Defender Office here on behalf of Eric Brown.
All right.
May it please the court, the state appears by Principal Assistant Solicitor General Natalie Chalmers.
All right. Welcome back, Ms. Chalmers. Counsel, would you like to reserve any time for rebuttal?
I would, thank you. 3 minutes.
3 minutes are granted. You may approach and begin.
May it please the court, counsel. Andy McGowan with the Appellate Defender's Office here on behalf of Mr. Brown, Mr. Eric Brown. The interference statute in this case required that Mr. Brown knowingly interfere with the officer's attempt to serve the warrant on him. If Mr. Brown didn't know there was a warrant for the officer to serve, how could he knowingly interfere? That's why we're here. The state should have to prove that Mr. Brown knew that there was a warrant out for him to convict him of knowingly interfering with his service. Without that knowledge, Mr. Brown simply ran away from a police officer, which is not in and of itself a crime. For there to be a crime in Kansas, there must be an act and a culpable mental state, as the statute calls it, or as Blackstone put it, a vicious will. In other words, to be guilty of a crime, the person has to know that the person is committing a crime. In an interference case, the person should know that the person is interfering with the service on him. The other requirement in Kansas is that if there is a culpable mental state, then it applies to all material elements. In this case, the state had to prove that Mr. Brown knew 2 elements. The first concerned acts. He had to be knowingly obstruct, resist, or oppose the service. The second, though, applied to the principles I have mentioned. And the state had to prove that Mr. Brown knew or should have known that the person was authorized to serve process.
I'm going to stop you. So we have a Kansas Supreme Court case, State v. Murin, that I think is taking a look at this exact issue. And my understanding in the holding of that case is that the statute you're referencing modifies only the defendant's obstructive conduct. So it doesn't require proof that the defendant understood the officer's specific duty, and there was no requirement that he understood the underlying process. So what do we do with that case?
Okay, Murin is complicated. I've spent some time in my briefs on it. I can't say that I understand it. I think it's wrong in so many ways, but I will say this.
But we are bound by it.
I understand that. I will say this. Its ultimate decision is that, well, there is this requirement in the case that the person know the officer is authorized to serve process. And they puzzle about this. They don't know where it came from, right? But then they conclude, right, that because that was in there, that even if they had some sort of concerns with it, what they were trying to decide was whether an intoxication defense would have been appropriate with the jury instructions for interference, and they concluded that it was. I think that's just like, I don't understand that at all, because the statute itself says that knowledge is simply a general intent crime, not a specific intent crime. And of course, you have to have a specific intent crime for the intoxication defense.
Let me ask you this. So setting the law aside for a moment, I believe the evidence in the case, and I think it was from like a body cam, Doesn't Mr. Brown at some point say, I know I have a felony warrant?
He does.
Okay.
Yeah, the evidence in this case isn't as I would have it if I were to make it up. But
So do we even need to reach this question then, in light of the
no,
evidence?
no, I am not admitting that the evidence is sufficient to establish that he knew there was a warrant. Okay. Now he says, whoops, sorry. He says this, right? But he says it after the police officer said multiple times to him, there's a felony warrant out for him. And I think it's actually significant that he says it in the present tense, not in the past tense. He doesn't say, I knew there was a warrant. He says, I know there is a warrant.
Well, let's back up. So I think that the setting with this is Mr. Brown is at a shelter. And the officer sees Mr. Brown, and if I recall, says something like, Eric, you have an arrest warrant. And that happens very early on in the interaction, motions to him with his finger, and then Mr. Brown takes off.
I think there are three significant moments in the factual basis here, okay? That's the first one. But the officer is talking to a closed door, a closed metal door. It's got a window in it, but he testified that he just said it. He didn't say he yelled it. He just said, you know, Eric, there's a warrant out for you. That doesn't mean that Eric heard it. And that's where I'm going with all of this, right? There's no evidence that he heard any of this. So there's that moment when this started. Then there's the moment when the police officer turns around the corner, right? But he's 50 or 60 yards away from him. So he's a football field or more away. And the officer does yell. You can hear it on the video. Again, there's no indication that Mr. Brown heard that. And then finally, we were just talking about the business about where he said, yeah.
Can I ask, when we're talking about knowing, you know, that there is a warrant, that an officer is validly serving on you, would hearing an officer say, you have a warrant, make it known? What makes it known?
I think so.
Okay.
Okay. Now, the other evidence could be, say, a probation officer called him up and said, hey, you got a warrant, right? So a week later or 2 months later, the question is, does he have a warrant? You call the probation officer. Now, that doesn't happen very often because probation officers keep that under wraps usually. That's the thing. Warrants are hidden usually until they're served. And that's the problem that we have here. So I think if the police officer said it and the person heard it and then continued, which goes back to when he said it, he'd already been arrested. So if he continues it, you know, I don't have any argument against that.
Okay. So your contention isn't that the officer would somehow need to flash some sort of sealed signed document in front of him and get his affidavit that he agrees that this is accurate.
Not at all.
Just the officer saying it and him hearing it.
Would be sufficient.
Okay.
Are we allowed to make reasonable inferences?
I mean, if I
We're looking at
yell,
the evidence in the light most favorable
If
to
I-
the state. I mean, I don't know which way you'd like to look at it.
Would you move over and discuss the alleged error calculating the criminal history? So we get to.
Sure. So 216810, the warrant in this case is based on 2 felonies. And the 2 felonies are in one case, right? And so the district court used both of those cases to increase Mr. Brown's criminal history score. I'm saying you shouldn't have been able to use either of them. The whole idea of whether it's a felony warrant or a misdemeanor warrant is based on those convictions, right? And
Well, let me stop you. So when you look at the interference statute, the portion of it that classifies whether it's going to be a felony or a misdemeanor, the language there, it doesn't actually require a conviction. It can just be in the case of a felony. And sometimes you see these crimes get charged interference without an accompanying felony charge. And you just interfered in a felony investigation that never gets charged. So if a conviction is not required, you know, why is this error to use it in a criminal history.
Well, in this case, there were convictions. That's, and I'm not being flip about this. I mean, there are differences. I mean, when you look at the obstruction statute or the interference, whatever you want to call it, what, there's 7 or 8 different ways you can do it. I mean, there's all kinds of variations. And I'm just saying in this case, the criminal history score statute says you can't use certain criminal histories. And I'm saying that at least in 2 of them, I'm arguing 3, but I think at least in 2 of them. So it changes it from a misdemeanor. One of them changes it from a misdemeanor to a felony. And the other one, the other reason that you can't do that is that was an element. And I think it was an element in this case because it was given to the jury. It was a stipulation that it was a felony warrant. And in the case, the state was, unless there was a stipulation, they were going to put on evidence of what the convictions were. So I think it's an element, at least as far as the statute is concerned. I also think it increases Mr. Brown's liability to a felony as opposed to misdemeanor. Does that answer your question?
Is there any case law supporting your position on this?
I couldn't find any. This will be the first one.
On a roll today.
I know that makes
Theme today.
I know that makes you all very happy.
Yes, you did answer my question. Thank you.
Okay. There is one thing I'd like to point out about Murren again, because that is a problematic case for me. But as I said, when it ends up, its analysis, it says, even if we would question the propriety of the instruction. So it's not even inviting any kind of change. And there has been no case since then. The state hasn't pursued this. The PIC committee didn't change anything. In fact, they have a pretty extensive analysis of Murren in the jury instruction for this.
Counsel, have you taken a look at that obstruction statute and tried to diagram that sentence? I'll admit that I spent some time trying to do that and trying to figure out what knowingly actually modifies.
Well, I mean, knowingly starts it out, right? I didn't do that. I probably should have.
I
But
mean,
what I was relying on is the relationship between knowingly and the rest of the elements. Under Kansas law, under the statute, the culpable mental state statute, if there's a culpable mental state, in this case, it's knowingly, it applies to all material elements. And so far, no court has found that the person knowing that there is a warrant out for them is a material element. I'm saying that it is, and it's the only thing that makes this different from a consensual encounter. The person's knowledge that there's a warrant, he's interfering with the service of the warrant by running away. So my time's about up. Any other questions for the moment? Thank you.
thank you very much. We'll look forward to seeing you on rebuttal. Ms. Chalmers?
So, I'm sorry, actually, that's someone bring water. So this court is duty bound to follow Murren. I would say that this statute is the most judicially grafted on element statute that I think we might have in the code. There's the substantial hindrance part. There's adding on that apparently you have to know that the law enforcement is law enforcement. If we were to go back to the plain language of the statute, I think a reasonable reason would just be that you have to knowingly obstruct, and that's it. And the rest of it in your diagram doesn't make any sense if you keep adding the word knowingly to it. But regardless, this court is duty bound to follow Murren. And Murren has said that it only goes to the actus reus, not to the intent. And I do think that there is an issue where here, the defendant keeps saying, well, you have to have a criminal intent, you have to have a criminal intent, and that's true. And we do, it's knowingly, you have to knowingly obstruct. We don't have to have a criminal intent for each and every element. That's never been a legal requirement. And it is the Kansas legislature and its interpretation of how it wants to do statutes that controls, not the United States, perhaps own the Ramiri case that controls. But regardless, you don't really have to reach that issue. I think you could duck this entire thing in this case, because this is a case where it is a sufficiency of the evidence issue, and it's a light most favorable to state. And here we have a defendant who was told, Eric, you have a warrant. The defendant then immediately flees, showing a consciousness of guilt. As he's running, the officer very loudly yells again, you have a warrant. Stop, which, by the way, when you were told to stop by law enforcement, is no longer a voluntary encounter. So I don't think that we were still in voluntary encounter land at that point anyway. That was a lawful command. He keeps running despite that, then is apparently found sitting, and you can watch the videotape. He's very belligerent, and he does eventually say, he talks about actually first, he talks about how, well, it's just a misdemeanor, it's not a felony. He's upset that he's being arrested on the felony. And then he says, I know I have a warrant. Under the very favorable standard of review for the state's going to win this case. This is enough to prove knowingly. So I'm not sure you have to get into all the complicated legal issues if you don't want to. If you do, great. We probably could use some interpretation of the statute. And I think, honestly, some court at some point needs to figure out what the actual elements of this case are, because it has been judicially crafted elements, and we're not usually a judicially crafted element state in the modern era like we were apparently when they crafted the elements here. So for those reasons, the state would say you affirm on that issue. On the second issue,
Counsel, before you move to the sentencing issue, could we, your opposing counsel argued that the statement was, I know I have a warrant. Does that present tense matter in your view, or instead of saying, I knew I had a warrant when I ran, or something along those lines?
I think that perhaps past tense would be stronger, but no, I don't think it matters. Again, it's the light most favorable to state. We can assume that, again, from being told twice and the fleeing, well, being told twice and fleeing, that was knowing even without that statement. But the statement just builds the state's case that, in fact, that this man knew he did have a warrant while he fled from the officer. I guess there's more. I would also point out that I don't think it's a wise decision by either the legislator or this court, whoever gets to make the call, that we want the state to be able to prove the defendant knows he has or she has a warrant. In some cases, that might be easy. If the officer says, like happened in this case, hey, you have a warrant, and then the obstruction happens, that's fine. But oftentimes the obstruction might happen before the officer says that. So now we have to sit there and prove, and you knew you had a felony case, you didn't appear, so you have to assume that at that point, you know that the warrant's going to issue. You have a bunch of probation violations. Your probation officer decided to rat you out and is trying to get you violated. It's going to be a lot of bad facts. In fact, this defense counsel in this case made it pretty clear that he did not want anything additional in. And while, yes, you can do the old chief stuff to some extent, it's a lot more difficult to craft that. I think when you have to prove this kind of knowing, it's not impossible, but it may be something where we sit there and we say, well, we're the state, we have the burden of proof, we have to prove this. And this isn't 6455 necessarily, it's an element of the crime. Typically facts that are the element of the crime come in. So I think it will cause a lot of problems if this becomes the rule.
I'm a little bit interested in the idea of trying to figure out what this means. And your argument is interesting that the only knowing is to obstructing, resisting or opposing, I suppose. Does obstructing, though, doesn't obstruction mean stopping something that should be lawfully happening?
And I think that's how you have to know their law enforcement got grafted in, honestly. I think that they said, well, they have to, yes, you have to obstruct, you have to know something should be happening. So they said, well, law enforcement giving lawful commands, essentially. So you have to know their law enforcement, and then here, no authorized to serve process. So I can kind of see how they get there, but I do think it's a lot of judicial writing of the statute still, that we're going to continue that, which so far Byrne has said, yes, we are, because it wasn't raised in that issue. That makes more sense to me than saying you have to know that you have like an actual warrant instead of just a lawful police action here. Like you
Right.
can't,
Okay, and then there are all of these other words. It literally could just say knowingly obstructing, resisting, or opposing law enforcement in an official duty, but instead it has all this extra stuff. And so I guess why?
it used to be two statutes. This statute gets challenged all the time, so I'm a little more familiar with it than I would
great.
like to be perhaps. And so it used to be two different statutes. I think Randall Hodgkinson pointed that out in one of his briefs, and he was right. And so they used to have the official duty and used to have the obstruction, and then they kind of just recodified, I guess, and threw them all together, and it became even messier than it was. And then when they did that, they didn't actually, it would have almost been nice for them to go and look at, here's what the, courts have said are our elements, and figured out if they wanted that or not. This is a statute that would not hurt to be cleaned up in some way, shape, or form. And I think that everyone struggles because of that fact. But right now we all just go along with the case law, and I guess no one's mad enough to go to the legislator yet. So, yeah. And again, you can avoid all that difficulty just by saying, okay, fine, even if knowingly is a requirement here, the state proved it. But going to the first issue, which was the criminal history challenge, there is no element here that requires a conviction. There is no conviction required in enhancement. This isn't like the first or second or third, which is usually when we can't use it again. I think the issue just lacks merit, and that's why there's no case law on it. Unless there are any further issues or questions, I would respectfully ask that the district court or the defendant's sentence and conviction be affirmed.
Any other? All right, thank you, counsel. Mr. McGowan, you have 3 minutes.
The Murren case, if you take it as the state wants you to take it, it's a strict liability crime. And it's not a strict liability crime. It starts out with knowingly. It can't be a strict liability crime. That's one of the problems I have with Murren.
How do we distinguish this case from that, though? And given that Murren exists, like if assuming that we can't overrule Murren, because I don't think that we can, then how would we rule in your favor?
The same way the PIC committee came to the conclusion that Murren didn't change anything. What happened in Murren was this like 5 or 6 page analysis of obstruction and like trespass or something, criminal trespass or something. Anyway, and they were trying to figure out whether either one of them were specific intent crimes so that intoxication defense could be used. And then they concluded that, well, a knowledge-based crime like interference is a is the specific intent crime, but it's not. And it's also not strict liability. So what happens is they go through all this analysis and then they end up with this conclusion that, okay, well, there was this instruction in here. We don't really understand why it was there, but it was there. And because it was there, we think that the intoxication defense should have been given. And it says, it concludes by saying that even if we were to find that this was wrong, it was right in this case. So when it concludes, even if we refer to it, this is not even an invitation. This court's aware of when the Supreme Court says, hey, get on this, right? This is not that invitation. And the state never took it up. We don't have any case law on it. Murren stands for the proposition that an intoxication defense instruction should be given if it's factually appropriate in a case with interference. That's all it is. So anyway, thank you very much, unless the court has any further questions.
All right. Thank you very much, counsel. Thank you both for your briefs and for your oral argument today. The court will take the matter under advisement and